Thank you all for continuing to stay with us on this exciting day. If I could encourage you to quiet down or take your seats for us to launch into the historical panel. So my name is Noah Rosenblum. I'm a law professor here at NYU, and it's my absolute privilege to be facilitating our third panel of the day on historical antecedents. While everything may feel unprecedented, if you know any historian, you know their favorite thing to do is to say, well, actually. So this is a whole panel that hopefully is going to take us beyond the simple, well, actually, to consider some of the lessons or not that history might have in store for us. I'm not going to introduce our panelists. They are illustrious, well known to many of you, and you can find their full biographies in your handouts. Being historians, we've elected to proceed roughly chronologically, which means the first comment will come from Julian.
Thanks, Noah, and thanks so much to the organizers of this event for inviting me and for everyone being here. It is such a pleasure to be part of this conversation now and to have had the chance to listen to some really terrific engagement over the course of the morning. The panel's brief is to talk about history during a period of flux, and that's a broad charge. Very broadly speaking, it occurs to me that you can think about the role of history in times like these, the role of history in the context of efforts to reform, to engage, to react to flux, as being a place you can look for models, both what to do's and what not to do's, but also a place that you can look to see how the process of change was managed and advocated for, sometimes in reference to historical claims themselves. And that's the latter, that's what I'd like to spend some time talking about, is to talk a little bit about the way history has been, in the Anglo-American tradition, repeatedly a source of validation, legitimation, and argument for movements that themselves were pretty disruptive in pretty profound ways. I am only briefly going to touch on the founding, actually, but that still puts me, I think, at the chronological beginning, because of course, an enormous amount. There's the vein of social contractarianism, which is, deeply subversive in some important ways of tradition itself. Unquestionably is important during the late 18th century in North America, but also and simultaneously alongside sort of more disruptive theories of political right, was a deep vein of claim that the revolutionaries and then the constitution makers were seeking to capture, recapture ancient liberties, ancient ways of being, ancient rights as Englishmen. And that move itself has a long grounding in English history, and the ways in which it's partly wished for and imagined history and partly real history is interesting. You see the same sort of thing moving through the early 19th century. It's fascinating to me how the legislative debates about internal improvements, both at the state level, meaning basically public works projects, which were controversial both constitutionally and from a policy perspective, both at the state level and at the national level, very often speak, sometimes with a shadow of defensiveness, those advocating pursuing internal improvements, about the rich, long legacy of government positive leaning and activity into which their efforts fit, even though the things they were doing were a heck of a lot more expansive, a heck of a lot more geographically invasive than the precedents they were working from. Maybe in some ways that's an example of kind of classic presidential thinking that comes naturally to lawyers and legislators, but internal improvements represented a transformative and indeed administrated evolution, a very complicated one institutionally and logistically, and it was defended in the course of an elongated process of actually implementing the agenda, to the extent you can call it just one agenda, in substantial part in relation to its continuation of a tradition, its reflection of deep values and practices, even where that wasn't exactly entirely true. What I want to spend most of the balance of my time on is looking at two more recent examples of appeals to history from people and in service of causes that we think of rightly as being like obviously revolutionary or obviously transformative might be a better word than revolutionary. I want to talk a little bit about the anti-slavery Constitution, and I want to talk a little bit about the New Deal and arguments marshaled in favor of reformists in both those areas. Because, of course, the movement of the 19th century abolitionism, is immensely disruptive and in a very profound and systematic way, like upsets and unsettles deeply entrenched elements of how American tradition, how the lived experience of the way things work operated, not only in the slave states, but also in the rest of the Union, which is obviously bound up in economic interdependence with the slavocracy. And it's interesting to me, and always has been, to read people like Douglas and Garrison and see how much of their arguments in service of really radical transformation of how things are done are grounded, and not around the edges, but like centrally grounded in, sort of channeled through an instinct to appeal to American traditions. And there's a well-known difference that Garrison says it's a constitution's the deal with the devil, it's pro-slavery, like, set the document on fire. Douglas says, no, it's a constitution that's against slavery. What I think is interesting about reading what they each say is that actually Garrison is grounding a lot of what he's saying much more in appeals to history and historical values in the Anglo-American tradition than might seem immediately apparent. So I'll read a few little things and then move on to the New Deal. And this was a really significant theme that carries through for Garrison. In the interest of time, I'll skip over Douglas, who I think is probably better known, because often assigned, I hope anyway, in constitutional law classes. Garrison, over and over again, throughout his career of intensely moralistic and like extremely purist anti-slavery evangelizing, comes back over and over again to the 4th of July and the Declaration of Independence and the obvious move in some important respects about the declaration that all men are created free and equal. But it becomes the framing for his arguments that in Christianity, actually, sort of the Christian commitments, which is a different kind of historical tradition, which I will set aside, but it becomes a framing for his intensely emotive and incredibly, I think, effective arguments around policy, morality, what's right, what's wrong. But he's not operating only in the sphere of what's right, what's wrong. He's arguing specifically in terms of the lived values and traditions that we have been committed to over the course of our collective political experience. 1828, he opens his first major public speech by saying, 53 years ago, the 4th of July was a proud day for our country. And he goes on to talk about all the things you'd expect. I do not claim the discovery as my own, that all men are born equal, and that among their inalienable rights are life, liberty, and the pursuit of happiness. And then he pivots with this frame, overarching the entire thing, grounding it in the Declaration of Independence to say, every 4th of July, we produce our Declaration of Independence with a sublime indignation to set forth the tyranny of the mother country. Here comes the pivot. But what a pitiful detail of grievances does this document present in comparison with the wrongs which our slaves endure. And so that's the capsule for this message is historical values, historical commitments, deep tradition. And I'm going to set it up for you. Now I'm going to pivot and do all the arguments that I have about how we really need to change this thing and how at odds with what's actually happening on the ground. I mean, he doesn't remain in high abstract mode. He pivots and digs in deep into detail. But the vessel is from the beginning to the end of this first major outing, a vessel that is put into historical terms. He does the same thing in 1854. I will trust you to believe me on that. I think it's interesting to see the ways in which FDR, in talking both about the New Deal and then sort of the folks who are working with and for FDR on preparing the APA, also insist, not in a backhanded sort of like rearguard action kind of way, but on leaning into the idea that what we think, and I think rightly, right, less so than the very traditional story suggests, but I think rightly is a pretty transformative and radically expansive moment in American history to administrative governance, is framed in terms of a redemption, a reclaiming of the way things used to be, of historical values and ways of being. I mean, his New Deal speech, where he uses the phrase New Deal for the first time, he begins, it's not the very first sentence, but it's very early on in his speech. Let us now and here highly resolve to resume the country's interrupted march upon the path of real progress. And he really means it when he says resume. He talks about recent decades as having been a period of loose thinking, descending morals, an era of selfishness, We must return to higher standards and abandon the false prophets. He talks about citizens cherishing the hope that our old standards of living, not meaning like, or not only pre-crash, but going back into the 19th century, our old standards of living and our old standards of thought, not just like, where's the money, but like the way we used to think, the way we used to be. Is he right that that's how we used to think and be? Maybe, maybe not, but he's making the appeal, have not gone forever. Just because I can't resist one more observation, and then I will stop. I'll leave the Administrative Procedure Act report off of my presentation. Trust me when I say the first entire chapter talks about how deep a vein in American history agency, action, and operation had. Like, that's where they started in pitching the APA, was like a whole chapter on how we've been doing this always and forever. I really liked this from FDR, though. Framing what we think of is like a pretty, I don't know, 19th century, late 19th century quasi-distributionist, not quasi, just redistributivist agenda as being like, actually like the traditional American spirit. There are two ways of viewing the government's duty in matters affecting economic and social life. The first sees to it that a favored few are helped. That theory belongs to the party of Toryism, and I had hoped that most of the Tories left this country in 1776. So obviously there's a lot of complication in terms of the practice of history properly done as compared to its invocation opportunistically as part of an advocacy project. I hope that I at least personally am able to keep those things separate as I engage in at least some of each things at different times. But I do encourage, especially in an era where there is, and rightly and understandably, a concern, second-guessing, complicated relationship to American history, that we don't forget, at least pragmatically and instrumentally, the power of appeals to tradition, the power of appeals to Americanness, even if it's at least a somewhat, a radically incomplete account of what it means to be American, as a way to achieve change through an appeal to redeeming what's true and best about ourselves. I think that we see that working over a long period of time, and that's my thoughts here.
Dan?
Thanks to everyone who made this conference possible, and especially to Noah. By January 1935, Felix Frankfurter had long been in the habit of giving Louis Brandeis's views of recently announced decisions of the United States Supreme Court. In that month, Frankfurter gave Brandeis's review of Panama Refining Company versus Ryan. The decision struck down a section of the National Industrial Recovery Act, which I'll refer to as NIRA, passed in June 1933. It authorized the president to prohibit the interstate transportation of hot oil, petroleum produced in excess of quotas set by state regulators. Writing for an 8-person majority, Chief Justice Hughes declared the section unconstitutional on 2 grounds. First, because it did not define the circumstances and conditions in which the president was to act, and second, because it did not require the president to find on a record facts that were conditions preceding to his actions. The first holding was the first time the Supreme Court voided a federal statute under the non-delegation doctrine. Only Benjamin Cardozo dissented. One might have expected Frankfurter to object. After all, he subscribed to James Bradley Thayer's view that courts should strike down legislation, should not strike down legislation unless its constitutionality was so clear as to leave no room for reasonable doubt. Further, Frankfurter was one of the nation's foremost advocates and defenders of the administrative state. And in 1933, at least, he thought that the National Recovery Administration's codes of fair competition might give businessmen the confidence to raise wages. Yet, Frankfurter preferred Hughes' opinions to Cardozo's. The chief did pretty well, though, as so often, he was not sufficiently compact. In the oil case, Hughes wrote to Brandeis, "As a matter of dialectic deductions from prior cases, Cardozo was certainly not unjustified. As a matter of statesmanship, he lacks experience of what these things imply." How Frankfurter came to praise Panama refining is a long story, but here's the short version in 5 paragraphs. 1, During the drafting of NYRA, Charles Wiesanski, who owed his appointment as Solicitor of Labor to Frankfurter, feared it would be declared unconstitutional and proposed language to square it with the non-delegation doctrine. When Wiesanski failed, Frankfurter advised NRA lawyers to build up a body of administrative precedent that might save the statute when the Supreme Court heard the inevitable challenge. Two, Wiesanski briefly feared that NYRA might bring authoritarianism to the United States. In the summer of 1933, NRA Administrator Hugh Johnson, frustrated with delays, abandoned the original plan for NRA, which was to organize only the industries with the largest number of employees. Instead, in the Blue Eagle campaign, NRA would whip up patriotic fervor to induce employers throughout the economy to sign individual agreements with the president in short order. These would be replaced with codes adopted through ad hoc deal-making with dominant firms in an industry. Mussolini's March on Rome, Lenin's seizure of power are no more epoch-making than Roosevelt's program, Wiesanski wrote to his parents. The moment we begin to govern by propaganda and mass opinion and to abandon orderly processes in which everyone is given an opportunity to be heard, the moment we give power to and encourage action by vigilantes, there will be arbitrary decisions, suppression of unpopular thought, and a general incentive to tyranny. 3, Frankfurter's circle ultimately decided that NYRA had brought not authoritarianism, but a different kind of illiberalism. Wiesanski's initial impression proved accurate. The bill makes a noise like a dictatorship and government control, he reported to Learned Hand. But it may really mark the beginning of cartels without much government supervision. NRA lawyers below General Counsel Donald Richburg never stopped telling administrators they needed to compile an evidentiary record to support the necessary findings of fact. But they never fully recovered ground lost when they were overviewed by a headstrong administrator whom Jerome Frank said acted as if he always knew what he was doing, but didn't, and by their general counsel, who put his personal quest for power and prestige against such constitutional niceties. 4, although we remember Panama Refining for its first holding about delegation, the court was at least as concerned about NRA's departure from the lawyer-dominated procedures of public utility commissions. In 1931, an address, Hughes had called upon agency lawyers to, quote, keep unscrupulous administrators in check. Neither the appalling arguments of the assistants to FDR's first Solicitor General, nor the revelation that agency lawyers had inadvertently repealed a crucial section of the Petroleum Code assured the justices that Roosevelt's lawyers were meeting the moment. And although the Attorney General's remark in Cabinet that NYRA's constitutionality really didn't matter may not have reached the court, Senator Robert F. Wagner, he was the Senate sponsor, his drunken statement to that effect at a dinner party surely did, because the two other guests that evening were Cardozo and Harlan Stone. Unsurprisingly, a Frankfurter protege liked what he heard at the oral argument of Panama Refining. The justices, using questions proposed by Brandeis, were, quote, really concerned with the fundamentals of representative and responsible government, Paul Freund reported to Frankfurter. All in all, a salutary approach. 5, agency lawyers promptly invoked Panama Refining, renewing their campaign for better records and findings of fact. Other lawyers wrote the procedures NYRA lacked into the legislation of the Second New Deal. The story of Panama refining has implications for how we understand the New Deal and for the present. First, it calls for a less dichotomous understanding of the New Deal than one often encounters in debates over the administrative state. The debaters have, in effect, divided past legal actors into opposing teams and ascribed to their members a fixed set of beliefs. Team New Deal's members, apparently, all sought unbridled discretion for administrators so that technocratic elites could import social democracy to America. You would never imagine that some New Deal lawyers champion legality within the administrative state. What might the story teach us today? To be honest, things you probably already know. One, even very good government lawyers can't save ill-conceived initiatives if their superiors care more about their personal advancement than the rule of law. Two, the Supreme Court can be an ally in government lawyers' attempts to be guardrails of liberal democracy. Finally, to succeed, the lawyers have to have a president who respects what Franklin Roosevelt called in his first inaugural address, the essential form of the Constitution. The court packing plan, and I should add now, the dismissal of William Humphrey notwithstanding, Roosevelt did respect the essential form of the Constitution.
Next is Joanna.
So thanks so much to NYU Law Review for inviting me to participate in this great event with so many scholars I admire. So I've been writing about the development of administrative rules protecting physically disabled air travelers in the 1970s and 80s. This is a period where activists are pushing airline regulators to make a rule protecting them. Significant pressure from physically disabled travelers starts in the early 1970s, and the results include regulations in 1977 and 1982, a federal statute in 1986, and regulations promulgated under that statute in 1990. Now, as you all probably know, this is also happening against a background of not just critiques of economic regulatory agencies generally, but also critiques of aviation regulations specifically, resulting in the deregulation of airlines, or at least rate and entry aspects of airlines, and the full elimination of the Civil Aeronautics Board, which closes its doors on the last day of 1984. So all of the mobilization and strategies of physically disabled passengers are taking place in enormous area of flux of their particular regulatory area. And so I want to emphasize for my talks, bring our attention a little bit to what's at stake with everything we're talking about, right? What's happening when we're talking about administrative law challenges, why that matters. This is all part of a larger book project where I'm talking about how administrative agencies serve as sites of mobilization for interest groups. Agencies are, of course, where a lot of activism is happening because that's where the power is. That's where the law is being made. And that's where you can find federal officials who have at least some discretion to interpret the law at a practical level and administer the law. And the administrative process offers a lot of opportunities to be heard by federal officials through comments and complaints and hearings and enforcement actions. And so lots of different grassroots groups, public interest groups, all manner of groups see administrative agencies as the place where the decisions are actually being made about the specific issues they're interested in. It's also an opportunity to mobilize, to publicize your issues before the federal government, to get some sort of ear of the federal government, and to mobilize around and gain followers. And administrative law, of course, shapes these opportunities, creates these opportunities, limits these opportunities in various periods. So when administrative law is in a period of flux, it means that you're changing the playing field on which all of this political activity is happening. So what can we learn from people organizing for federal protections from airline regulators when the ground is shifting beneath them? Some background. So physically disabled passengers had long suffered discrimination from airline staff who would often turn away passengers traveling on their own who appeared physically disabled to untrained staff, people who used wheelchairs, people who were accompanied by guide dogs or used white canes, on the grounds that it sort of just generally wouldn't be safe for them to fly on their own without some sort of attendant. Airline staff would often bar such people from traveling, citing some sort of mysterious federal law or an FAA rule that said they had to be accompanied by an attendant. This often humiliated passengers, many of whom were traveling for work, many of whom were lawyers and disability rights activists who were traveling to DC to lobby, who were experienced flyers, and who knew full well there was no such law that actually required them to be accompanied in any way. But federal law did delegate significant discretionary authority to airlines on matters of personal safety, which did give enormous discretionary authority then delegated to airline staffers without any rules to guide their discretion. In some cases, and this is so sort of individually discretionary, in some cases, the gate agents would allow passengers who use wheelchairs or canes onto the plane, but then the captain or flight attendants on board would say they couldn't fly and would have them arrested and dragged off the plane when they resisted deboarding. Passengers wanted regulators to use their regulatory authority to make a uniform rule that would prevent airlines from doing this, that would actually bind all airline staff evenly and prevent airlines from just simply throwing off planes such passengers. Their public pressure and their campaigns targeted the Civil Aeronautics Board, the Federal Aviation Administration, and the Department of Transportation, drawing variously on the Federal Aviation Act's non-discrimination language, the obligation of common carriers, and later Section 504 of the Rehabilitation Act of 1973. So it takes a long time. The more than 15 years of notices of public rulemaking and hearings and lawsuits and demonstrations and arrests to get protective rules and statutory language. But eventually it is sort of effective. In 1986, Congress passes the Air Carrier Access Act that bans discrimination against physically disabled passengers. This is 4 years before the Americans with Disabilities Act. Airlines are not covered in the ADA because 4 years earlier there was this sort of very specific legislative success regarding airlines. Okay, to be clear, some of the challenges and some of the reasons it took more than 15 years to get some significant movement on this issue were not necessarily tied to deregulation happening in the background. There's a significant tension between the authority of the Federal Aviation Administration, which has authority over safety, and the fact that the Civil Aeronautics Board had authority over discrimination claims. And so they're sort of batting this issue back and forth like a hot potato for some years, both issuing notices of public rulemaking and then the issue sort of disappears. And neither agency was particularly committed to the issue, and so they're not pursuing it on their own without these pressure campaigns. And when airlines told regulators that they needed to be in charge of these sort of individual decisions based on safety, administrators tended to believe them. Of course, rulemaking in this area was made that much more challenging by a political environment in which the regulators themselves are sort of, as it turns out, fighting a losing battle. It's a political environment generally in which activists face a general lack of political enthusiasm for more regulation. Instead, you have conservative economists and policymakers pushing to turn things over to the market. Physically disabled passengers did not believe that market-based solutions would make industries more mindful of their concerns because it never had. And we're talking about a relatively small percentage of air travelers that airlines felt pretty confident just simply disregarding. Political opposition to rate and entry airline regulation results in the deregulation of the CAB, which starts winding down in 1978 and closes its doors at the end of 1984. And from the late 1970s on, then, airlines are saying, well, it's just simply ludicrous for a board that's going to be shutting down to be promulgating new rules. How on earth could that even happen? And also, with the deregulation process, a lot of the authority that had been built up in earlier years to handle consumer matters, to handle matters of non-discrimination, is just simply terminated, and it's not passed on to the Federal Aviation Administration or the Department of Transportation. And then court challenges in this area become that much more difficult when Reagan's Department of Justice is very eager to limit the reach of federal civil rights laws. But even as the regulatory field kept shifting, disability rights advocates adapted and sought protections and allies wherever they could. As agencies are gutted or they close, it doesn't mean the external demands go away. It meant they had to shift their target. So activists look to the Federal Aviation Administration. They draw on other statutory language that exists as a path in. They pursue congressional support in addition. Even after Congress did, in 1986, act to explicitly ban disability discrimination. Of course, that just simply pushes the issue back to the Federal Aviation Act, which has to make has to promulgate regulations under that law, the single sentence that Congress passed. But it's also worth thinking in these times how government regulation leads people to expect certain kinds of things, certain kinds of civil rights, certain expectations of non-discrimination to be policed by government agents. Some of this comes from the agency itself, right? Even when an agency disappears, it leaves its imprint on the law. It has constructed in certain ways the expectations of groups fighting and leaves its imprint on the development of policy going forward. So to sum up, administrative reform may change the playing field, but the game goes on.
And finally, my own former administrative law teacher, Nick.
Thank you, Noah, and thank you so much to the organizers for the opportunity to be here. I think history does a couple of things that help explain why the present moment is one of such great uncertainty in terms of the anti-administrative jurisprudence of the judiciary and how that may interact with the new administration. So the first thing I think we can take from history is about the nature of trans-substantive law. Since at least the early 20th century, admin law has purported to apply uniformly across many different substantive areas. The case law tends to abstract away from the specific agency involved. But if we look beyond APA text and its trans-substantive interpretation and look at things like the distribution among different agencies of challenges that are actually brought and the identities of the parties bringing the challenges and the challenges' outcomes, we find that any given trans-substantive principle can have quite uneven distributive consequences in terms of advantaging some interest groups or political movements over others. These consequences may be intended by the lawmakers who enact the principle or by the judges who articulate the principle, but the very nature of trans-substantive principles means that some consequences can be unpredictable and unintended. We see these dynamics in Joanna Greisinger's previous work on the early APA in the 1940s and 50s, as when newly stringent standards of judicial review that were general in terms had a predictably disproportionate effect on the NLRB. Or when the court's unexpected application of general procedural protections to immigration proceedings prompted a congressional rollback specific to immigration. Other examples can be found with the advent of hard look judicial review in the 1970s. As documented by Tom Merrill, hard look's earliest exponents, like Skelly Wright, meant for it to put a thumb on the scale for left-leaning advocacy groups. But in the long run, hard look ended up being used by industry just as much and arguably more. A second thing I think we can take from history is about how the federal judiciary, given the indeterminacy of many legal questions, has tended to have a certain relationship to the national political parties. And here I'm drawing on the work of my colleague, Keith Whittington. Over the last 200 years, most federal elected officials have remained broadly supportive of the federal judiciary's power because the judiciary has, most of the time, been aligned, broadly, though not perfectly, with whichever national political party coalition mostly holds power in each historical era. For example, the judiciary from the 1890s to the 1920s was broadly aligned with the dominant Republican Party coalition of that era for building and integrating a strong national market. The judiciary from the 1940s to the 60s was broadly aligned with the dominant Democratic Party coalition of that era for trying to reduce economic and later racial inequality. Now, you might think that this understanding reduces the judiciary to being merely a passive follower of national politics, but as Whittington notes, it isn't that simple. The party in power may sometimes be pressing a program on which it is internally divided. In that scenario, the judiciary can exercise its own outcome-determining power while retaining political support for itself if the judiciary aligns with a combination of the dissident faction within the majority party plus at least some of the minority party. So for example, this is what happened in the 1890s when the Supreme Court limited the Sherman Antitrust Act at a time when antitrust's proper scope was an issue splitting each of the parties. And also when the court struck down the Democratic Party's income tax from 1894, on which support within the Democratic Party was extremely uneven. So, what do these two historical points about trans-substantiveness and parties tell us about today? To use Gillian Metzger's term, we see an anti-administrative jurisprudence on the federal bench today, as in the major questions doctrine, the demise of Chevron, and efforts to toughen the non-delegation doctrine. And all of these anti-administrative doctrines are trans-substantive to some degree. But just how many substantive areas each of those doctrines will really bundle together remains pretty unclear. And that unclarity interacts with another kind of unclarity regarding the judiciary's current relationship to the party system. Now, the classic political science model would be to expect a rough but meaningful correlation between each of the justices and the party of the president who appointed them, including the 6 Republican appointees. But if you want to use that kind of model, you have to define just what is the Republican Party that you are trying to use as a reference point. Since 2016, the Republican Party has seen great instability and rapid change in both its coalition and its program on entitlement spending, national security, international trade, immigration, and more. Now, to be sure, the 6 conservative justices share a common skepticism of agency power as it exists in the regulation of private business. But beyond that core, the regulation of private business, it remains unclear how broadly anti-administrativism will sweep, how wide its trans-substantivity will be, and how these unknown future formulations will end up aligning or not with a Republican Party coalition that seems in many ways to be equally in flux. To illustrate, consider the uncertainty about whether and how anti-administrativism may apply to government spending and to foreign affairs. Justice Gorsuch's dissent in Gundy, joined by Roberts and Thomas, suggested the non-delegation doctrine should apply to regulation of private conduct, but not to government spending and not to foreign affairs. And Gorsuch later said the major questions doctrine is based on the non-delegation doctrine. On that, he was joined by at least 2 justices. Prompted by this, the Biden Justice Department, in the student loan forgiveness case, argued that the major questions doctrine should only apply to regulation. It should not apply to government spending. But then the conservative majority responded emphatically that the major questions doctrine does apply to spending, pointing out that that is what allowed the MQD to rescue Obamacare back in King v. Burwell. Gorsuch joined the student loan majority on this point and was silent on how to reconcile that with his prior opinions. Then again, in the recent emergency order on grant cancellations, the student loan majority, minus the Chief Justice, now has suggested a different way of possibly unbundling much of spending from regulation. That is, grant cancellations cannot be challenged under the APA, but only in the Court of Claims, where judicial remedies are slower and less far-reaching. Now, besides all this indeterminacy about spending, there's also the question of foreign affairs. Does anti-administrativism apply to foreign affairs? And if not, how is this exception for foreign affairs to be defined, and does it include tariffs? Philip Hamburger, author of the leading book advocating anti-administrativism, argued strongly that foreign affairs are accepted from core constitutional constraints on administrative power, but he also argued that tariffs do not fall within a foreign affairs exception. Consistent with this, as Katrina and Tom talked about in the morning, Hamburger's New Civil Liberties Alliance is now leading the charge against Trump's tariffs, invoking the MQD and non-delegation. Tariffs could split the Republican Party coalition while mostly unifying the Democrats, which is just the type of scenario where, historically, a Supreme Court appointed mainly by the dominant party can decide big outcomes and retain support politically by siding with the dissident faction of the dominant party coupled with the opposition. Now, that's a possible future, but hardly a certain one. History does not predict the future, but it helps explain why prediction at this moment, I think, is particularly hard. Thanks.
Thank you for those wonderful opening remarks. In a moment, I will be encouraging you to start writing your questions on note cards so you can pass them to me. I have a couple of rounds of questions for our panelists, but first, for those of you in the room and online taking this for CLE credit, I have our next CLE buzzword. The word of the afternoon is jarcacy. There's actually a bit of a debate in the legal profession about how to pronounce this word. I'm grateful to whoever told me that it's pronounced in the same rhythm as pleurisy, so that's why I've gone with jarcacy, but the spelling of the name in the case is Jarkesy. Again, your CLE code is jarcacy. Okay, so please write down any questions you might have on note cards to pass up. I'll start with a couple rounds of questions for our panelists. So first, I want to spend some time looking backwards and thinking about a kind of unexpressed tension. So when I teach administrative law and I touch on the history of administrative law, there's a temptation to focus on moments of grand settlement. I'm thinking there's a famous article about the Administrative Procedure Act called A Fierce Compromise. Joanna's wonderful book, which I recommend to all my students, challenges that in some key respects, so I really do commend it. But there's this idea that there have been these kind of moments of administrative settlement when we've come to agreements and have agreed on the rules that we play by. But across all of your 4 opening remarks, I see a world of constant political tension. The New Deal moment that Dan is reconstructing for us isn't one in which people agree on a kind of paradigm shift and work within it, but where internecine political fights are constantly dominating. Or Joanna's story of what's happening in airline regulation is a place in which the ordinary political conflicts that we're all used to happening all the time are just taking place in new fields in which people are using them. In Nick's remarks at the end, he drawing on Keith Whittington's work, he's foregrounding this sort of political dimension to these conflicts. So the 2 questions that emerge from that, the first is, wait, am I perpetuating a real mistake when I teach administrative law to my students as involving certain moments of settlement? Would it be better to think of it as just another fight of perpetual conflict in which the same rules of ordinary political conflict that characterize the rest of our lives are also just playing out in administration? And then there's a related question, which is, well, what about that whole vaunted politics versus administration dichotomy? Are these stories in which we see that actually administration is just politics all the way down? Or is there some integrity to that distinction, which was pretty core to at least some of the theorists of administration? While our panelists are thinking, I'll encourage you to write down any questions you might have for them on note cards to pass up here.
I don't know that I have something particularly insightful to say as an answer to the question. I will maybe extend it and suggest the stakes of extending it, which is that I'm put immediately in mind of the long-standing, centuries, millennia long-standing tension between purpose and text in interpreting enactments of various kinds, including but not limited to legal ones. Because one of the ideas behind purpose of interpretation is that you can discern some core of purpose, some shared underlying set of assumptions in a majority coalition from which you can derive some information about how to further sharpen how to apply a text in places where there might be more than one view of how it applies on its face, or might even fight the way it seems to apply on its face. And to the extent that what you're describing is right, and I certainly think it is, it becomes tricky, because one answer to your question might be, well, it's not that hard Noah. I'm joking. It's not that hard. What's fixed is fixed, and what's not is not. They had a whole lot of things that they contested, and they settled some things, and they didn't settle others. So read what they wrote, and what they settled, and what they did, they didn't. And that escape doesn't work because of the text purpose problem, which is to say, insofar as we do turn to purpose as a way to think about supplementing or sometimes undercutting text, that relies on what everyone knows to be, to some substantial extent, a fictitious attribution of collective meaning to a really messy, like multi-individual process across lots of different mediating institutions. But on the other hand, isn't entirely made up and not entirely not true. So because nobody else was answering, I just said the thought that I was thinking, and now I'll let somebody else explain how we answer what has become an even more difficult and important question, I guess.
I mean, I think if you look into Keith Whittington's work, which is some of the work I've found especially helpful on thinking about, kind of judicial power and executive power and history and how it can, give some insights into how the whole system operates over time. I mean, Whittington does suggest that there is a kind of settlement most of the time, but we've been through sort of a series of settlements, each of which starts in a period of kind of rupture and reconstruction, and then there's a period of calm. And in most of these periods of rupture, you have a new president coming in with a new political coalition who has to deal with the legacy court from the previous regime. Nixon and Reagan dealing with the legacy of the Warren Court and the liberal D.C. Circuit, or Roosevelt dealing with the legacy of kind of the Wilson, Harding, Hoover appointees, and so, but it's not again entirely clear how to apply that framework to our present moment. What's quite interesting is that a good deal of what the administration is doing right now, as others have mentioned, is in some ways inspired by and using the language of the Roberts Court. And yet, at the same time, some of the very aggressive use of statutory authority seems to be very much in tension with some of the other marquee precedents from the Roberts Court. So there's a kind of split there, which I think again underscores the unpredictability here.
So my first take at this would be kind of the tension between thinking about the problem that you identified, like historically, like a historian would do it, and then also the close enough for government work when it comes to teaching the history in a substantive law course. And particularly when you're dealing with statutory systems, that first chapter in the case book is the origins myth of whatever field that you've got. So it's, see, children, there were labor injunctions, and they were terrible, and they were awful, and the courts did not realize the limitations of their institutional role, and that's how we got the National Labor Relations Act. And of course, the APA is like super important there. So some of it is just translating history in a laudable attempt to suggest to law students and others that, their present is constructed in some sense by the past. That does end up fudging or imposing a particular periodization on it. That said, I think even when you're looking at it as a historian, there are periods where there are kind of settlements. I mean, I'm very grateful to Adrian Vermeule for a review of my book, which called it a portrait of an equilibrium. And I think he accurately captured what I was doing, which was describing at a time when administrative adjudication was principally what was going on, a solution that was reached. But, that may have, your question may suggest that that may have been obscuring some of the really conflict and change that was not resolved at that period.
I would just say, to really build on what Dan said, I think this gets to some of the central questions about doing history, which it just sort of depends on how you're looking, how you're framing the story, like what part of the story you're looking at, right? The history of the NLRB in the 1940s looks very different from the history of what Congress is doing around administrative procedure in the 1940s, but of course they're happening at the same time and they're in conversation. You can only look at so much at any given point, but acknowledging that all histories are a little bit partial, and sort of how you frame the story is going to sort of end up in a more or less controversial story. And of course, there's also the question of where you start and stop the clock. If you stop the story in 1946, once with the the Administrative Procedure Act or the National Labor Relations Act, et cetera, it looks more like a settlement than if you time it somewhat differently. If you start there, if it's just a midpoint in a much longer story. And so those are just sort of inevitable choices about narrative on some level. And as to the politics and administration point, this is not exactly an answer, but I will just say it's useful to think about the way that talking about administration can help us hide the politics, often intentionally, right? Conversations about expertise, conversations about the public interest can happen on this level that seems to be outside of politics. But of course, if you talk to anybody on the ground in any of these issues, they're absolutely not. And so there's sort of a rhetorical feint there as well.
So this is great. So to maybe build on this last question and connect it with some of what we talked about earlier today, the first couple panels were talking a little bit about doctrine, and we saw in some of those doctrinal discussions the importance of history in a few different ways. We saw the importance of historical narratives that came up. We saw, or at least had references to, some of the different historical doctrines the court has relied on itself, including the weight it might give to institutional arrangements in thinking about administration. And of course, we're familiar with other areas of law in which the rise of history and tradition style analysis has begun to inform how the court is supposed to make sense of the questions in front of it. Many of the historians resist strongly the idea that the past provides a simple set of rules that we can abstract from to apply to today. The four of you nevertheless went out of your way to suggest some lessons we can learn, but these lessons weren't quite connected to doctrine, and interestingly were not in connection with some of the ways we saw history informing the continuing development of administrative law this morning. And so you don't have to answer this question, but if you'd like, I was going to invite you to think about whether any of the stories that you just told, or any of the other history you know, connects to the modalities of historical intervention in administrative law that were flagged for us this morning, whether it's the question of narrative, as Joanna, you were sort of alluding to right now, the history and tradition element that we see coming up in other areas of administrative law, or the weight the court might give to practice in thinking about administrative arrangements going forward.
I mean, I guess I'd say that in the originalist debate about the non-delegation doctrine,
About the what?
I mean, one explanation for why so many proponents of toughening the doctrine have said that it should be focused on or maybe apply only exclusively to regulation of domestic private conduct is that there's such a large amount of legislation that was enacted by Congress in the 1790s that seems to give very broad delegations, but a lot of it applies to foreign affairs or involves, what used to be called privileges, benefits, subsidies, government services, that kind of thing. And so, I've always wondered how much the current, somewhat narrow formulation of the non-delegation doctrine that you hear from some but not all of the advocates of toughening it, arises, from some kind of value system, that is, really about, deep moral values of liberty, that Chris Walker was talking about this morning. or is just kind of drawn forensically from what position proponents of a tougher non-delegation doctrine seem to be boxed into based on the evidence that they have to work with in the 1790s. And I mean, I'll add the disclaimer that I would argue that there actually is legislation in the 1790s that's broadly delegatory and domestic and coercive, but still most of it is not. Most of it falls into these other categories. But there's always been these two things come together. The forensic history and a certain kind of liberty-based moral value system. But I don't know which is determining it or if it's just a coincidence.
Okay, fussy pedantic thing. I'm absolutely happy with the caption, lessons from the past, because, you have to do things compactly in captions. I'm always a little uneasy with the idea of lessons from history because it seems to displace the responsibility for decision-making upon the past. It's not me that's telling you this, it is the past that's telling me this. And I actually know how open-ended the past is. So I kind of prefer analogies because that puts the responsibility on us to decide whether the past is a good analogy or a bad one. But that's kind of a fussy point. I don't teach the administrative law class, and to be honest, I don't spend that much time in the present. So I'm not great about engaging in particular, the FCC case, for example, on non-delegation. There are people in this room who could say whether the analogy is better or worse than I could. I do think, like, on the level of engaging with narratives, I do think history is kind of important. I've already alluded to in the talk how I feel the New Dealers get caricatured. I think the other way that is kind of important to me in the work is that the notion that the alternative, I'm sorry, Chris, the alternative freedom is some sort of, realm of liberty, in which I know that progressives were already dealing with a very party patronage dominated system that was already on the ground. Skowronek said it's not building a state, it's building a new American state that happened with the progressives. And so it may help, sometimes it's an engagement with a narrative that I don't think that paid sufficient attention to what the political world was that the progressive state was built upon.
I would say that the more time I spend with, detailed, thick engagement on historical questions around how governance, institutions, administration worked, the higher my own internal bar for thinking about how sure you have to be before an appeal to history and historical expectations becomes anything like decisive ought to be. And that the bar that's set, and not only by the currently dominant judicial coalition, but it's true also on the left and the right, the bar that's set for a level of certainty I think it's one thing to invoke history in political context, and I meant for my conversation earlier to talk about how history is used in service of an essentially legislative political advocacy of trying to change the way things are. In a legal context where you're trying to resolve legal questions in reference to especially distant understandings of history, the more you see how polyvocal the past is, the more you see just the sheer quantity, at least in we're lucky enough in the American tradition to have a pretty thickly documented archival information set relating to elite activities by elite political actors, which is a super important aspect of thinking about history and its implications for, well, its own sake, and then trying to draw a conclusion there. Here's what I'm coming to. The more contested I see things, the more I see how pervasively contested things were on more or less pick your any topic you want, the higher my sense of deep suspicion is about claims that this is how they thought for any period that the word they is being used in relation to. and certainly for any conclusion that that history, insofar as it's an input on historical legal interpretation, compels us to conclude something. One thing that I really struggle with in this respect, sort of analytically, is, again, I don't think it's a struggle historically. I think the history and the project of history doesn't, this is not a question that's presented for history in the project of history, but where you're looking for ways of doing things, you can find, it has been my experience that you'll very likely find analogs to contested ways of doing things today of some kind or another in the last 200-300 years, which actually in historical terms is not all that long a period of time and is embedded in a pretty similar way of thinking about institutions and politics historically, like in terms of the grand scale of history. But there's also a question about, if you're going to look to history for a guide, how much does scale matter? Right? I can, scale meaning like quantity, instances of occurrences. I can absolutely point to lots of conversations about, let's say, the Commerce Clause or the Necessary or Proper Clause that engage in purely effects-based reasoning that indeed lets you regulate, like, the farmer's wheat crop if you follow that. Right, like effects reasoning is there from the beginning. They talk about it. They recognize it goes very far. Did they regulate that often to the scope of that full capacity in these periods of time? Might they have thought about it differently or pushed back differently if they had? I think that's a really hard question to answer across a range of topics. Not historically, from a history perspective, it's super interesting and fun to see ways in which, like, it's indeterminate and the evolution depends on the questions. Like, that stuff's great. But if you're trying to draw lessons from the past, if I think about the evidence for regulating inaction, the evidence for delegating, the evidence for what I think is fairly called administrative executive adjudication, the evidence for a really broad effects-oriented rationale around Necessary and Proper Clause or Commerce Clause, it's all there. 100% it's there. It just wasn't happening anywhere nearly as frequently as it does now. And should that make a difference doctrinally? I can see arguments that it does, but I have no idea how to think about formulating it crisply. So weirdly, the more I shift into historical mode, the less certain I become at all about how history ought to influence doctrine.
So we have a couple questions from the audience. So several of the panelists referenced the relationship between the judiciary and administrative law or decision-making that has administrative implications. Of course, the relationship between the judiciary and politics has changed over time. For instance, as Dan knows, it used to be normal for Supreme Court justices to have presidential ambitions or to be advising presidents even while on the bench. By contrast, today, judges are often tied to political legal movements that have a slightly different configuration. So what do we make of these changes? Do these institutional changes alter the dynamics that, I guess to invoke the absent Keith Whittington again, that Keith Whittington has flagged for us? Do they affect any of the lessons we might consider or draw about the relationship between the courts and administrative decision-making?
I think this is an important area to explore more. I mean, the question of what is the judicial career, because I mean, as the questioner suggests, it used to be that, you know, people would become, eminent federal judges, and they wouldn't think that that was the end of their career, right? I mean, Charles Evans Hughes left the Supreme Court to run for president. William O. Douglas thought he was going to leave the Supreme Court and run for president, and furthermore, I mean, also, I mean, all this, you know, kind of interchange between, you know, the political sphere and the judicial sphere, and also the fact that most Supreme Court justices had not come from lower federal courts. I mean, we're now in a scenario where, you know, you kind of go into the federal courts and, you know, the main path of advancement is through, you know, White House appointment to a higher court. I mean, that has to, I suppose, affect people's conception of their role, their incentives for all sorts of things, it's possible we'd have a rather different model if a judgeship were more clearly, just kind of the capstone that came, toward the ends of one's long legal career, as opposed to something that people go into in early middle age and, see the main path of advancement as being, kind of appointment to a higher court from there.
It's a Danner's question.
I know. Dicey has just spoiled me. So I did a Fulbright in New Zealand once. The original Court of Arbitration in New Zealand did have to be a justice of their Supreme Court who hated doing the arbitration work because the bench had been recruited from a bar that really viewed itself more as barristers in the English sense, and just could not be more bored with trying to figure out wage schedules rather than arguing about principles of law. And when finally a judge was separated to just have that court and expected to be promoted into the real Supreme Court, all the judges turned on him and said, oh, no, you have too narrow or limited a jurisdiction, and you haven't actually been trained in like the principles of common law and freedom like those of us who have been at the bench and bar have. So this is an old argument about whether the DC Circuit should be made of people who are litigators and know DC law. And I do think there is actually something that is maybe anti-administrativist, but certainly fans of due process. If you have a judiciary that is principally staffed by litigators rather than those who are law professors maybe, or people in, I guess now, deal-making. Was it the litigators who resisted settlement at Paul Weiss rather than the deal-makers? So, yeah, I think there's a spin, depending on what branch of the profession is in the judiciary.
I will just say, just to bring into that question something we were talking about this morning, is that when we have this conversation, which is important and obviously central to administrative law, is the importance of bringing in Congress. And I just want to echo that as well. And I think there's a disciplinary divide here, too. I think a lot of legal scholarship and also legal historians tend to sort of give Congress to the political scientists, and we study the courts and the agencies, and then the political scientists don't necessarily study the courts with Congress. And so, like, everybody's sort of doing a different thing, but everybody in this room knows, like, it's all wound up together. And I think that's an inseparable part of it as well.
So one last question. The emphasis of the panel has been on analogs, lessons. We've really been leaning on the side of continuity, or at least looking for prior examples. But as I like to needle my students, everything that happens is both continuity and discontinuity. Can we lean a little bit on the discontinuity moment to before we end? So is there anything about the current moment that strikes you as genuinely unprecedented in this moment of flux in administrative law? Is there something going on that is not like what has come before?
I mean, yes.
30 seconds each. Actually, we have 4 minutes, and then I think we even have a coffee break. But let's not go into the coffee break, since I know that Don worked incredibly hard to find the room in the schedule for it. Am I remembering this right? Am I reading the agenda the right way? So let's go to 2:30. Joanna, do you want to start us off?
I mean, yes. As lots of people haven't really dug into it in this today, but so much of what's happening is just contrary to law and contrary to statute, and going in and just saying, yes, Congress appropriated, and this happened, and there was notice and comment rulemaking, we've done it all, and we're just turning the money off, and nobody exactly knows how to turn it back on. I mean, what are we doing? Right, we're talking about administrative law as sort of an ongoing concern, but I mean, I guess, question mark?
You know, that last paragraph of my talk, every point that I pointed out, you are implicitly to draw the negative. No, I mean, you know, the quality of government lawyers, who's going to be government lawyers now. The point about a president who respects the essential form of the Constitution. So yes, everything's changed.
On the main point, I can't improve on what Joanna said at all. One thing that came up last night that in conversation among some of the folks here strikes me as pretty relevant, which is the idea that there's a lot of different ways in which the statutory structures and judicial doctrine, but especially statutory structures, create outs and escape routes and options and alternatives for change, for like deviating from the baseline, from the status quo. For the executive branch to do that, and the president specifically, for the really good reason that there are times where you don't think everything out correctly ahead of time, and it's hard to tie everybody down at all times to some vision that you freeze in time, right? Like building in some flexibility around exceptions, right? Like Schedule F is grounded in a provision that's actually there and that actually makes some sense. And if you go across a whole range of statutory schemes in which these kind of exceptions to, available alternatives to, the general thickly worked out like default ordinary process are read turning the volume up to 11, you're right. We talked about in terms of the presumption of regularity. If you're assuming from the perspective of something like a presumption of regularity in an executive that respects the underlying spirit of the laws, as corny as that sounds, in addition to just literally obeying the letter, then the use of all these little things that these outs from the ordinary operation of all these statutes is like wildly abusive, but it's actually a little bit hard to articulate in some of the cases. Some of the cases not hard to articulate at all. But like why, how, and in what way is the activation of one of these escape routes to like undo everything instead of being a minor exception to the overall project? Like how do we talk about that being executed in such a systematic way as to represent like an evulsive break as opposed to just kind of the, you know what executives do, they push the limit. It's more than that, it's more systematic than that, and it has to do with like the need for flexibility in the law and the systematic abuse of like every outlet for any kind of flexibility.
I'll be contrarian just to be contrarian. When the Civil War broke out, the North said that it would conduct a naval blockade of the South, which is a coastline of 3,000 miles. No naval blockade at that scale had ever been conducted before, and everyone who knew about naval warfare said in 1861 that it would be completely impossible. The United States rapidly built this huge navy and succeeded in blockading the South. It was one of the greatest achievements in naval history, one of the great achievements of American state building, on a very rapid schedule. In 1865, after winning the war, the US sold off that navy with incredible speed so that it had almost no naval capacity and had a smaller navy than Chile by the 1870s. And this was done quite deliberately for political reasons because a large navy was considered politically threatening to a republic as it was then conceived. Because if you had a large navy, it would inevitably draw you into, the global rivalry of the imperial powers, which was thought to be incompatible with American government and values. So the idea of destroying institutions because their very existence goes against a certain deeply held political value system is, something that's certainly happened before in various ways. Contrarian just to be contrarian.
So I just can't resist. The rise and fall of the Navy is, of course, at the root of the removal power jurisprudence that is before the court soon in Humphrey's executor. So history, even in its intricacies, turns out to be at the foundation, whether continuous or discontinuous. Please join me in thanking our incredible panelists. That is super interesting. I never knew that. It makes so much sense.